Hello and welcome to the final session for today called Standard of Care for Design Professionals. Our speaker for this presentation is Katherine Jones, and you can get started whenever you're ready.
Hi, everyone. Super excited to be here today. I'm sure it's the end of the day for everyone else, and you guys are getting a little tired. So nothing like a little legalese to get everyone all excited again. Like Emily said, my name is Katherine Jones. I am an attorney with the law firm of O'Hagan Meyer. A little bit about myself. I have been practicing law for a little over 2 decades. Almost all of my practice deals with construction or trucking in some shape or form. But the biggest part of my practice is the defense of architects and engineers for breach of contract and negligence claims. And basically what we're going to be talking about today is what is the standard of care for design professionals. And a lot of what we're going to be talking about today will deal with Illinois. But if anyone has any questions about any other states, I will give you my details at the end of the presentation. And I'm more than happy to answer any questions that you may have. So let's get started. Today, we're going to talk about 3 different types of duties, as we call them in the legal world, that design professionals can have towards members of the public and other third parties. The types of duties that we're going to talk about, just as a general primer, is we're going to start the presentation with the most common type of duty that you're probably familiar with, which is a contract duty. And as I'm sure everyone knows, a contract is an agreement, whether written or verbal, between, and it can actually even be implied by conduct, but it's an agreement between 2 or more parties where the parties essentially agree to certain terms and conditions. Your typical contract is I will buy 10 widgets from you if you pay me $10. The second type of duty that we are going to talk about today is a tort duty. And I'm sure everyone is familiar with torts in some way or form. A tort is essentially a civil wrong as compared to a criminal wrong. Torts go way, way, way back. They were prevalent in Roman society and they came up in Germanic law. But torts really came into their own in England through the common law. And we'll talk about this a little bit more later, but common law is where we get torts. In common law is essentially interpretation of regulations, statutes, laws, and cases that courts decide on specific sets of facts. The tort that most people are probably the most familiar with is a car accident, where you have a duty to other pedestrians or drivers or passengers in other motor vehicles not to hit them or do something negligent so that you injure them. The third type of duty that we're going to talk about today is the one that you may not have run across in the engineering profession and is probably the least common, but is growing, that we'll talk about at the end, which is a fiduciary duty. And a fiduciary duty is the highest duty that you can owe legally to another entity. Essentially, you're placing your client's interests ahead of your own. And we see fiduciary duty in limited circumstances, such as, a trustee of a trust, or is kind of everyone's talking about now, Jamie Spears being the conservator for Britney Spears' estate. That's a fiduciary duty. And so we hear about all sorts of wrongs he committed in the news. But today we're going to go through these 3 types of duties, and we're going to talk about what is the duty essentially, and how does it impact you in your engineering practice, and to whom do you owe duties? What are the universe of people or entities with whom you need to be worried about owing these duties? So let's jump in with all of that said. Like I said, the first duty that we are going to talk about today is a contract duty. And as I said earlier, everyone's familiar with contracts. a couple things I want to just note before we get into a little bit more on contracts. Contracts in the law assume that the parties have equal bargaining power. And this will become important later when we talk about fiduciary duty, because contract duty and fiduciary duty have different assumptions underlying them. And fiduciary duty is often based on a contract. But sticking with our contractual duties for right now, contract assumes that the parties have equally bargaining power, as I said earlier, and it allows parties to agree to what the relationship is going to look like. It allows parties to agree to certain terms. It allows parties to agree to certain remedies. When design professionals engage in contractual relationships, one of the important things it allows design professionals to do is it allows them to allocate risk as well as costs associated with those risks. And you might see, terms and conditions in your contract like limitations of liability or who's going to carry insurance to cover a loss and those types of things. We're not going to get too in the weeds to those today, but those types of remedies are available to you if you contract. So, contractual duties. Who do you owe a duty in contract to? Obviously, the person or entity with whom you contracted is somebody that you are going to owe a contractual duty to. So if I enter into a contract with Joe Smith to buy widgets and I don't pay Joe Smith for the widgets, I owe him the money because we have contracted and I have assumed that obligation towards Joe Smith. Also, however, you can owe a contract duty to third parties who are not a party to the contract if the parties who engaged in the contract initially agree to confer a benefit on a specifically intended third party. And this comes up in contracts in construction all the time, and it comes up all the time with design professionals. And so a lot of times in contracts, you will see third parties mentioned. So for example, if a project owner contracts with an architect to perform design services, and then that architect subcontracts out to an engineer to perform some of the design services, the owner is not a party to the architect engineer contract. And therefore, the engineer does not owe a contractual duty to the project owner because they do not have a contract with each other. So sometimes to avoid that outcome, you will see contracts that will say things like the project owner is an intended beneficiary of this contract, which then infers contract rights onto the owner. Under Illinois law, however, if you want a third party to be able to sue on a contract, such as in that situation, you need to, in your contract, specifically designate that third party. And so a lot of times you will see contracts in which, the project owner is mentioned, maybe between a contract between an architect and an engineer, but courts have generally held that that's not enough to confer a benefit for that project owner to bring a direct suit against an engineer. Instead, there needs to be some really specific clause in that contract that confers that benefit. And a lot of times when you see contracts, you'll see language that'll say things like, this contract shall not be construed to create a contractual relationship of any kind with ... project owner. And the reason you see that kind of language is because the parties don't want the project owner coming back and bringing a claim directly against an engineer. So that is essentially the universe of people under a contract duty that you need to be concerned about. How does this look kind of in real life? And as we go through today, the slides today, we're going to talk about a number of cases so that you kind of get a feel about how these issues are applied in actual legal cases. This is not an Illinois case. This is a Washington case. But I think it illustrates the point in a really good way. So This case is called Virg versus Shannon and Wilson, Inc. And the case here, the facts are that the city of Seattle owned a piece of property that was a cliff, essentially. And the cliff oversat a couple homeowners' residences that were underneath the cliff. And the city hired Shannon and Wilson to do essentially a slope stability analysis to ensure that the slope was stable, in all likelihood to protect the private homeowners whose property was underneath. But Shannon and Wilson did a report, and they essentially recommended that the city of Seattle install some dewatering wells to be installed before the upcoming rainy season hits Seattle. Because the city of Seattle is a government entity that doesn't move as quickly probably as Shannon and Wilson would have loved, the city did not get the wells installed prior to the rainy season. It took a little bit longer than that, and a bunch of rain hit the cliff, landslide ensued, caused a ton of damage to the homeowner's property. The city of Seattle obviously has no real claim back against Shannon and Wilson because Shannon and Wilson made correct recommendations to the city about the slope stability and what they needed to do to ensure the slope was stable. However, the homeowners made an argument that Shannon and Wilson should have informed the homeowners about the slope stability recommendations in order to prevent harm to them. And the homeowner's argument was essentially that an engineer owes a duty to the public in general to keep the public safe. And part of the licensing regulations in Seattle said that an engineer had to look out for the safety and welfare of the public. And so the homeowners used this language in the licensing statute to argue, hey, Shannon and Wilson knew that a landslide could ensue. They knew the city wasn't installing the wells in a timely manner. And Shannon and Wilson should have come to us and warned us about what was coming up with this rain. In that case, the court essentially said that Shannon and Wilson had no duty whatsoever to the homeowners because they weren't in contractual privity with them, which is a fancy way of saying that they simply did not have a contract with them. And nor were they, what we talked about on the last slide, a third-party beneficiary of the contract between the city of Seattle and Shannon and Wilson. And so in that case, the homeowners were sent off without any damages. And so, I think that case is a good example of look at who you're contracting with, because it really, really will matter. And you need to look at the language in your contracts. So once we know who we're contracting with, what is the standard of care? So here we have the kind of standard form contract that I'm sure many of you have seen that is put out by the Engineers Joint Contract Documents Committee. This is the E500 form, which is an agreement between the owner and the engineer for professional services. I'm just going to read this to everyone so that we're all on the same page. What the E500 form says is that the standard of care for all professional engineering and related services performed or furnished by engineer under this agreement will be the care and skill ordinarily used by members of the subject profession practicing under similar circumstances at the same time and in the same locality. Engineer makes no warranties, express or implied under this agreement or otherwise, in connection with any services performed or furnished by engineer. Couple points I want to make about this language is that one, you will see this language or a version of this language in a lot of form documents or a lot of specifically manuscripted contracts that some of you may use. It is also essentially parrots the negligence standard of care that we will talk about in a little bit. But because it's by virtue of contract, you need to really watch what the language says, because that is the standard of care essentially that you're going to be agreeing to. And we'll talk in a couple of minutes about how just a couple of words in your contract can end up changing that standard of care, whether you wanted it to or not. This standard of care, however, is very, very consistent with what the negligence standard of care would be in Illinois. I also want to note that this standard of care does not require a design professional to be perfect. It simply requires the design professional to act as a similar member of the engineering profession would act in the same locality. So we do not have the same standard of care for somebody that is practicing, let's say in rural Wyoming, to somebody that's practicing in the city of Chicago. The standard of care arguably is different because it's based on your specific locality. Small aside before I get into a little bit more about the contract standard of care is that if you recall, the previous slide essentially said that the engineer kind of makes no warranties express or implied under the agreement. With that said, there is a doctrine called the Spearing Doctrine, and some of you might have heard of it. But what the Spearing Doctrine says is that an owner that retains a contractor to build a project based on the drawings and specs that provided by the owner. And here's the part that's relevant for this discussion. Whether those drawings and specifications were prepared by the owner directly or by a design professional separately retained by the owner, makes an implied warranty to the contractor that the drawings and specifications are sufficient for the project's construction. So by necessary implication, when you provide either specifications or drawings to an owner, you are impliedly warranting that they are sufficient for the project's construction. Despite whatever your contract says, the law is going to read into your contract that the product that you are giving the owner is sufficient for the purpose for which it was intended. Essentially, as it says on the slide, you are representing to the owner that the design is constructible and adequate for the purpose for which is it intended. So let's talk a little bit more then about how a contract duty can look and how it can change based on your contract. And so we saw from the E500 form, I think most contracts try to end up mirroring the negligence standard of care so that it is the same standard of care that you would owe essentially to the general public that you do to the parties with whom you are contracting. But that can go awry in a number of situations fairly quickly, which is why you always want to really take a long time and really read all the words in your contract, or better yet, have an attorney review them. But I want to talk for a minute about a Florida case called School Board of Broward County versus Pierce Goodwin. A little bit of background about this case. So Broward County hired the Broward County School Board contracted with an entity called Pierce Goodwin, which is an architecture firm, to renovate a high school. And there were a number of change orders that were generated through this process. And essentially, during the design phase, there was a ton of back and forth. And the school district had designated a peer reviewer to represent its interests that looked at all of the drawings. And the peer reviewer at one point saw that there was no third floor balcony, there was a third floor balcony, but it did not have a staircase. And the peer reviewer felt that a staircase was required by code, by the fire code, to be present in the designs. The architecture firm disagreed and thought it was code compliant without the staircase added. So there's a bunch of back and forth, and the contract says that the school district's peer reviewer has essentially not the peer reviewer, the building director had the final say as what was code compliant and what was not code compliant. And so a verbal conversation ensues, and the architecture firm Pierce Goodwin believes that they have the okay from the school board to eliminate the staircase. So they issue the final set of specs and drawings, and the construction begins. As you can probably guess from the fact that we are still talking about this case almost a decade later, the school board came back and said, oh no, there was a misunderstanding. You need the staircase. And now we have to put through yet another change order in order to construct the staircase, and it's going to cost us a ton of money. And the Pierce Goodwin came back and said, look, we got a verbal from you that we didn't need to construct the staircase, but even more importantly, we're within the standard of care. We acted as it's generally understood within the community that a staircase is not required for this third floor balcony. We've got other architecture firms that will say that. We think you are misinterpreting the regulations, and we don't think we acted outside the standard of care at any level. And the court on these facts said, look, you didn't agree in your contract to the ordinary standard of care that we would have seen in this, E500 form. What you agreed to and was to provide plans and specifications that complied with all applicable laws, statutes, rules, and regulations. And furthermore, you agreed that the building director for the school board of Broward County was the final say. Therefore, you might have acted in a way such that an architect would act in this locality, but that's not good enough because you agreed to a higher standard of care. You agreed to comply with all laws and rules and regulations, and you also agreed that those laws and rules and regulations would be interpreted by Broward County. And so based on that language in the contract, the school board ended up winning its case, and Pierce Goodwin had to pay the school board a bunch of money to construct the staircase. So that's an example where just something that you see typically in all contracts that, the architect or the engineer is going to provide plans and specs that comply with all applicable laws, statutes, rules, and regulations, ends up creating a higher standard of care than they originally intended when they contracted. Now, in this case, the standard of care was broadened through the contract. We also have cases where the standard of care ends up being arguably narrowed or interpreted to be narrower than the aggrieved party would like. So I have another case here. It's called Thompson versus Christie Gordon. This is an Illinois Supreme Court case that was issued in 2011. So in this case, this is an engineering case instead of an architecture case, but an engineer had a contract to design a replacement bridge that would be virtually the same as the one that was being replaced. And the engineer performed its scope of services to the satisfaction of the client. The bridge opened up, traffic was going on. Years later, a car hit the low median separating the lane of traffic on the bridge and vaulted into the median into oncoming traffic. The family of the driver ended up suing the engineer, saying that the engineer was negligent in several regards, including not performing a median barrier analysis, not considering the necessity of crossover protection, and not including a jersey barrier in its design. On these facts, the trial court in Illinois granted judgment for the engineer because the court looked at its contract and said it had met the the requirements of the contract and didn't have any independent responsibility towards the driver. The state Supreme Court, the Illinois Supreme Court, ended up upholding that decision. And the state Supreme Court said that the standard of care was limited to the degree of skill and diligence normally employed by professional engineers performing the same or similar services, which is the standard that we had talked about earlier in the E500 clause. And the state Supreme Court said, look, you contracted to replace the bridge deck, and replacing the bridge deck did not include improving the bridge deck or adding a jersey barrier. And so on those facts, the court said that the engineer's duties were confined to those duties and agreements that were specifically set forth in the relevant contract. And so this case is a good example of a contract that ends up helping the engineer by limiting the scope of its services to what it actually originally contracted for. Another case that is similar to this, it's Fennercheck versus the Village of Frankfurt, which is a pretty famous Illinois case. In that case, an Illinois civil engineer contracted with a land developer to design a subdivision's surface water drainage system and then to observe the construction. After the engineer completed the design and the developer accepted them, the Village of Frankfurt gave its approval to begin construction. The builder then constructed a custom home and sold it to the plaintiffs. A few months later, guys can probably all guess what happened. Water began to accumulate in the backyard, and the foundation grade elevation had been set too low and the basement flooded. Water damage ensued, and the homeowners brought a negligence claim against the engineer. Just like in the Thompson case, however, the Illinois court in that case said that you couldn't expand the engineer's duty beyond the scope of what was contained in the contractual agreement with the developer. And so because the engineer was not ever required to set foundation grade levels, that the homeowners just simply had no ability to bring a suit against them. And so again, look at your contracts. Contractual responsibilities are going to be the biggest and largest source of duties that you will have. And so you want to take a look at them, and you want to look at a couple things. You want to look at who you're contracting with, who you don't want to contract with, and make sure that those people are excluded from your contracts. You want to look at what the standard of care is in your contract, and then it's the standard of care that you want to be giving to the client. And you want to really look at what your scope of work is, because that is going to define the universe of things that you are responsible for to do within that standard of care. One more point that I want to make before we stop talking about contracts is contracts can get tricky because we can have a written contract and we can have a verbal contract. And so I'm gonna pull off a case that I had a couple of years ago where there was an engineer who had designed a water drainage system. They had finished the water drainage system years prior. And there were events that occurred in the drainage system due to weather events and things of that nature, including probably climate change, ended up where there was a bunch of debris stuck in a creek that ended up affecting the drainage system overall. And so the client ends up calling the engineer and says, hey, is this drainage system, is this going to be adequate moving forward due to the effects of climate change? And so we're going to talk about climate change a little bit more later on in this presentation. But for now, the engineer essentially said, yeah, I think it's fine. And so in that situation, I would submit that you likely have now just engaged in a new contract. And so you had the original scope of your engagement, which was to design your water drainage system. But then you have a new engagement when the client calls years later and asks another specific question, which is this system adequate for the emerging climate? And so that answer then can create an entire new engagement, an entire new contract, which can then lead to an expanded scope of your engagement. It can change the time frame of your engagement, and it can change the duties that you owe because you now have a verbal contract in addition to your prior written contract. And so that's something that you want to be thinking about when you're looking at your contracts and when you're entering into contractual relationships moving forward. So with that said, we're going to move into the second area of duties and where duties arise from. And this won't probably be as prevalent in your practice as contractual duties, but it will be a significant portion of what you want to be worrying about or thinking about as you enter into relationships. And so I'm going to start with a little bit of primer on what a tort is. As the slide says, a tort is a breach of a duty imposed by law. And there's a bunch of different kinds of torts. Essentially, you have intentional torts, which are things like assault and battery and trespass and things like that. You also have negligent torts, which are, your car accidents or your, professional liability for the most part. And then you have strict liability, which won't be something that we're going to discuss at any length here, but that tends to arise with products. So when you put a product in the stream of commerce, you are essentially warranting that it is fit for its intended purpose. So let's talk a little bit about negligence, which is where the scope of this presentation is going to focus. In order to have a negligence cause of action against another entity, you need to have four things. You need to have a duty to that person or entity. You need to have a breach of that duty. There needs to be proximate cause, which I'm going to talk about in a minute, and there need to be damages. And so let's talk about it first, the context of a familiar fact pattern, such as a car accident. So if I'm driving my car down the road and Joe Smith is ahead of me and I rear end him and I harm Joe Smith, what Illinois law says is that I can't rear end people while I'm driving for the most part. And so the duty arises out of Illinois law, which is that I need to drive in a safe, non-negligent manner. And I can't tailgate essentially. So I need to be able to stop my vehicle. Second, I breached that duty by not stopping in time to avoid rear-ending Joe Smith. I caused Joe Smith damage because absent my car running into his, he wouldn't have been injured. And four, Joe broke his arm in a car accident and therefore he's got damages. It is the most common type of fact pattern where you're going to see a tort duty and probably the one everyone is the most familiar with. It also transfers over to licensed learned professionals such as attorneys, architects, engineers, doctors, accountants, people that hold licenses that are granted by the state by virtue of their education and expertise. And so professional negligence is when a licensed learned professional acts in a negligent manner within the scope of their profession. So I'm going to talk about a little bit about proximate cause for a second, because proximate cause is one of the most confusing concepts in tort law. So proximate cause is one of those things where no one really knows what it means. And if you read a bunch of legal cases, you wouldn't really know what proximate cause was. In really simple terms, it means you caused a harm. A case in law school that a lot of law students get in their first year is called the Kinsman Transit case. And I'm just going to give you a 2-second overview of this case so you can see how kind of ridiculous the concept of proximate cause can get. But in the Kinsman case, there was, and it's an older case that happened in New York, but there was a boat that was improperly moored somehow. And the boat ended up drifting away and crashing into another boat. And then both of those boats floated down the river and crashed into a bridge. Then the bridge collapsed and ended up damming up the river, which in turn caused flooding to the land adjacent to the river. And so you kind of have just this like this stretch of causal events. And so the landowners ended up suing the original boat that wasn't moored properly. And they said, hey, I didn't cause this. There was 80 million things that happened before your land ended up getting flooded. You can't blame me for not tying my boat down properly. And the court in that case said, no, that is still proximate cause. And so proximate cause and duty, which I'll talk about in a minute, are kind of the two things that tie you to the outside world, in the outside world of those people with whom you don't have a direct contract. And so if you don't tie your boat off properly, you maybe owe a duty through the concept of proximate cause to a landowner that is very far away because a bunch of crazy events are going to occur. And so that's just something you want to keep in mind is we are talking about this stuff, is that it can get really kind of convoluted, but not to get too far into the weeds here. We pause for a second. All right, so let's talk about to whom we owe a tort duty. A duty under tort concepts can be to the other party in the contractual relationship, which we've talked about, as well as to any third party who is reasonably foreseeable that would be affected by the actions of a person. So if you don't tie your boat off properly, is it reasonably foreseeable that you could hurt an adjacent landowner? Possibly. Another case, just to kind of bring this foreseeability concept into perspective that I want to talk about, is another famous legal case called false graph. And this case comes out the opposite way, which I think makes it a good contrast to the previous case we talked about. So Helen Falsgraf is a 40-year-old housekeeper, essentially, who's taking her two daughters on a warm summer day in August of 1924 to the beach. And she's getting on a platform at a train station in New York, and she's standing there waiting for her train to come. While she's waiting, a different train pulls in. And two guys are late to get this train. And so they're running as fast as they can to get to this train. And the doors of the train are closing. And these guys kind of jump onto the train. One of the railroad employees pushes one of the guys' backs to get him onto the train as the doors are closing. He drops his suitcase. His suitcase, of course, contains a whole bunch of fireworks. The suitcase hits the railroad platform. It explodes. Helen Falkgraf with her two daughters is standing on the other end of the railway platform. The explosion causes a clock that is on the platform to topple over and hit Helen Falsgraf. So she ends up suing the railroad for essentially letting these guys on to the train while it was taking off, saying that they were negligent. So in that case, the court said, look, those actions are too attenuated. It was not foreseeable to the railway attendant when he helped the late passenger onto the train that the railway passenger would be carrying fireworks, that the railway passenger would drop the suitcase of fireworks, that the fireworks would then explode, that there would be a clock tower under which Helen Falkroth was standing, that the explosion would cause the clock tower to topple over, and that she would be standing right there and got hurt. And so how does this affect you as an engineer? Well, let's kind of get to that. For a tort duty, as I said before, you owe a duty to anyone that it is reasonably foreseeable that you could potentially harm. So if you do not have a contract or you have a contract and it is silent on the standard of care, we then look to the common law to determine what the standard of care is. And in Illinois, that standard of care is almost always going to be one of negligence. And so where does the negligence standard of care come from? And as we talked about before, it comes from a variety of places. It comes from cases like Pfaltzgraff or the boat mooring case, where just there's random things that happen in real life and they end up getting litigated before a court, and a court issues written decisions, and those end up becoming kind of the law of the land. It also comes from statutes and it comes from regulations. And so when you are practicing your profession, you do owe this duty to anyone that is reasonably foreseeable that you could harm if you act in a negligent manner. In Illinois, if you are defending a lawsuit for any reason, what Illinois law specifically says is that, and this is what a jury would eventually be told if you were on trial for something, it's the standard of care is, in performing services, an architect or engineer must possess and apply the knowledge and use, the skill and care that is ordinarily used by reasonably well-qualified architects or engineers. A failure to do so is a form of negligence that is called malpractice. And so again, it's the same standard we talked about in the contract, but this one is imposed as a matter of law in the absence of a different standard of care. If you are not in contractual privity with an entity, it's important to note that the damages that you owe to a third party are limited, generally speaking, under Illinois law. And what those damages are they're limited by what we call the economic loss rule. So to go back to our contract, if you are in a contract with somebody, you owe them, and you breach that contract, you owe them damages for whatever your contract contemplated. In tort, while engineers have a duty to members of the public with respect to personal injuries and property damage resulting from breaches in the standard of care, Illinois will not hold engineers responsible for economic losses. And what does that mean essentially? So if you're working on a project and there's some defect in the construction, and so they need the project owner needs to remediate, let's say you have water infiltration and they need to remediate some window jams or, roof or something of that nature. And the project owner sues you. And let's go back to our hypothetical where the owner contracted with the architect and the architect contracted with the engineer. The owner in that situation doesn't have a contract with you, and therefore the owner cannot sue you in most circumstances for their damages because their damages are purely economic in nature. And so what tort law is really concerned with, unlike contract law, is property damage or personal injury. And you might be saying, well, that is property damage if there's water infiltration of the building, but that was the subject of the contract. So it needs to be property damage to other properties. So maybe, bricks fall off of a building and smash a car underneath, then you've got property damage by the car owner. So that's the kind of the universe of people that we are worried about from a tort duty. So let's talk about tort a little bit more. So one of the biggest issues that I think design professionals and really all professionals are concerned with respect to tort is, who do I owe this duty to? Am I a boat owner that owes a duty to landowners 2 miles down the river? Or am I a railroad employee who doesn't owe a duty to a passenger on a different train? And so we don't really always know who we owe a tort duty to, and it can be kind of tricky to figure out. But the central theme is it foreseeable that if you do not practice in a non-negligent manner, that you could injure somebody out there? And so this comes up in a bunch of crazy situations, and I want to talk about some of them today just to kind of give you something to think about as you practice. So this is an actual case that I handled, and it was this case was an architect, but an architect was retained to essentially to design a municipal government complex. And part of that complex was a municipal lockup facility. And that lockup facility essentially just housed people that had been arrested for a bit, and I think, maybe a couple days thereafter. And so this architect ended up subcontracting, as an aside, to another architectural firm that specialized in the design of prison systems. And so in this case, essentially, and I'm going to flip the slide here, but this is a complaint that was filed, and there was a class of plaintiffs that ended up filing a class action against the municipal entity. And they said that the municipal entity's practice of allowing male arrestees, as well as its male employees, to view female arrestees while they were using the toilet facilities in the prison system violated the plaintiff's Fourth Amendment rights to privacy, to be free from unreasonable searches and seizures. So what does that mean essentially? So there was this lockup facility, and men were supposed to be on one side of the facility and women were supposed to be on the other side of the facility. And there's toilets in the lockup facility, and they're in specific cells, but there's a screening bar, but it's not, the allegation was that if a male walked by, they could actually see females using the toilet facilities. And the argument there was that was essentially, it violated those prisoners' rights. And the reason it violated the prisoners' rights was because the Fourth Amendment to the United States Constitution essentially says that prisoners essentially don't have any privacy rights once they have been arraigned on a charge. So once you go before a judge and you're arraigned, then you kind of lose all of your rights to privacy. And, if you're going to use a toilet, somebody can watch you. But before that, before you're arraigned, you still have a right, like a private citizen, to some level of privacy. And therefore, you have the right to use the toilet without somebody looking at you. And so I find this case so fascinating because essentially what they're saying there is that the standard of care in this case was that the architect had to understand that under the Fourth Amendment, that there was a right to privacy for any person that was arrested that was going to be held in that municipal lockup facility until they were arraigned. And they needed to design that facility in such a manner that nobody could view that prisoner pre-arraignment. After they're arraigned, there was no argument that the design was adequate. But the argument was that because there were prisoners in there that hadn't been arraigned, they had a higher right to privacy than the typical prisoner. And the architect didn't, the allegation was with the architect didn't design it properly because they essentially didn't understand the constitutional rights of the prisoners. And so there's a couple things going on here, which is one, is when you are designing, a municipal lockup facility, is a prisoner, a arraignment prisoner, are they somebody that is foreseeable to you? Is somebody that you could harm by allegedly negligently designing a toilet facility in a prison? And then the other issue that's going on is that the standard of care? Are you acting as a reasonably prudent architect in this municipality would have acted? Should you have known that the Fourth Amendment attaches greater rights to arrestees prior to them being arraigned? And, there's a whole bunch of, issues going on in this case. And it really kind of pushes at the edges of who are the people out there that you need to be concerned about, and who are the, and what is that standard? Like, how much do you need to know about what types of work that you're working with? Now, again, this is an architecture case, but I think, you can see how it transfer into other areas as well. And I know that the NSP Code of Ethics does say you should only be performing services in your area of competence. And, this architect did a really great job and hired a sub-consultant who specifically dealt with prison design. And so the design essentially was fine. And there was no reliability in the case, but it brings up kind of a whole host of issues as to what do you really need to be concerned about when you're working on buildings. Another issue that comes up in terms of foreseeability all the time is climate change. And so I want to spend a few minutes talking about climate change and whether or not climate change is foreseeable. And so the next slide here. So as we've been talking about, tort law generally does not attach liability to harms that were not foreseeable. And as we talked about earlier, tort law essentially relies on things like codes, regulations, case law. It also relies on things like, just generally the typical standard of care in an industry. And what's really kind of a new issue with climate change cases is that you really can't rely on applicable codes and industry custom for the standard of care. And why is that? The reason for that is that building codes and other types of codes generally are based on historical data. And that data does not tend to account for future risks related to climate change, such as sea level rise. And so when you're looking at historical data, it may not always be the best place to look for what's going to happen in the future when it comes to weather conditions and climate events. And so essentially, there haven't been a whole lot of cases yet where design professionals have been on the hook for issues related to substandard design for failure to account for climate change, but you can see them starting to come around the edges. And it comes back to this foreseeability issue. Is climate change foreseeable? And will it become more foreseeable as we learn more about climate change in the future? How would a climate change claim arise potentially? As I've said multiple times, if it's unforeseeable, no one has a tort claim. And so what is foreseeable is going to change massively geographically. So do we have rising sea levels in Denver? Do we have, multiple foot increase in average snowfall in Miami? And again, past performance is just simply not an indicator of future results. So you can't really, with climate change, hide behind contractual requirements that you're going to comply with building codes or applicable laws or industry custom, because you really need to start considering about how climate is going to affect design in the future. So one of the cases that's, again, we don't have cases yet directly that I'm aware of against an architect or an engineer for failure to design for climate change, but I want to talk about a case or two that's coming pretty close. And so the first case that I want to talk about a little bit today is Conservation Law Foundation versus Exxon Mobil. So Conservation Law Foundation is an environmental group, and they had a bunch of issues with a facility that Exxon Mobil built in Massachusetts. The Exxon Mobil facility that you're looking at here is it was built in Massachusetts, and Exxon Mobil received a Clean Water Act permit to discharge essentially pollutants into the water. The Conservation Law Foundation filed suit against Exxon Mobil for civil penalties, as well as seeking injunctive relief to stop the discharge of pollutants, saying that because Exxon Mobil had a permit under the Clean Water Act, that they were at, that there was an imminent risk that severe weather could cause discharge of pollutants greater than Exxon Mobil's permit allowed. So in other words, CLF was arguing that by virtue of this Clean Water Act permit, that Exxon Mobil was only allowed to discharge X amount of pollutants to the environment, and that they were one basically severe weather event away from discharging pollutants in excess of the permitted amount under the Clean Water Act permit into the environment. So let's talk about the specifics of this a little bit. What CLF argued under tort theory was that Exxon Mobil, when they designed the facility, failed to consider the imminent increases in rainfall, the severity of storms, and the sea levels. And essentially the argument by CLF was that Exxon Mobil did not engage in good engineering practice. Specifically to CLF alleged that Exxon Mobil's terminal had not been properly engineered, managed, or fortified to protect it from the impending threat of climate change related impacts. And CLF sought about $110 million in civil penalties to remediate the release of future pollutants. So Exxon Mobil basically comes in and says, these are future events. We're not worried about it. And also CLF can't kind of make a claim against us because nothing's really happened yet. And, I won't get into the legalese all around that. But what I think is really the takeaway for design professionals is that while no design professionals were named directly in the lawsuit, the court allowed the suit to proceed. And in fact, it's still pending. So we don't have an outcome yet. But the court basically said that CLF had standing to make a claim against Exxon Mobil for present and imminent storm related risks, because the court found that there was a substantial risk that severe weather conditions in the future could cause the terminal to release pollutants in an amount greater that was allowed under its Clean Water Act permit. And so you could see where Exxon Mobil then in turn, if it got hit with some sort of civil penalty, would then bring a suit for negligence against the engineering firm that originally did all the work for construction of the facility. And so that's a case that we're kind of monitoring. But, you know, I suspect that if an engineer ever does get brought into the suit, that they will argue that they did everything in accordance with the applicable codes and regulations. And the issue really is going to be, was it foreseeable that these climate effects or changes could come in the future and that there would be harm that came from it? Another climate change case that again, I think is, you know, interesting from the perspective of design professionals is Cole versus Collier. So in Cole versus Collier, there is again, a prison that is built. I think the takeaway here for everyone is not to take any engagements with prisons, but aside from that, there was a prison that was built in Houston, Texas, or I guess 70 miles from Houston, Texas. And the design of the prison was such that there were only some areas of the prison that were air conditioned. And, you know, part of the prison had a geriatric population that was a heat sensitive, essentially subclass of prisoners. A heat wave comes through, and the heat index, the evidence in the case was that the heat index showed that it was hotter inside 2 of the 3 dormitories than outside. And there was a bunch of heat related illnesses and deaths of prisoners that were essentially exacerbated by these heat waves that came through. And so the prisoners brought a 1983 claim, which is essentially just a claim for mistreatment by the prison system, saying that basically that they were entitled to damages because the prison subjected them to heat that was greater than was safe, and that was greater than the heat that they would have experienced if they were outside. So essentially, you've got kind of a claim that says that climate change is now resulting in a poor design, which is then leading to illness and deaths of some of the occupants of that building. Again, in this case, this wasn't a case against an architect or an engineer, but in this case, the court took judicial notice, which essentially means that the court on its own said, look, because of climate change, heat waves are frequent, more severe, and more prolonged. And because of that, the court ordered officials at the prison to provide essentially relief to the individuals that were getting the heat-related illnesses, including lowering the temperature in the housing units and installing window screens with gauges that block, you know, insects into the housing units. But that was another part of the case. But essentially, the court required a change of design of the building to require lowering the temperature within the housing units of the prisoners. And so again, there was no design professional that was implicated in this case, but you could see where a design professional could get brought in for failure to consider or at least advise about the potential impacts of future heat waves on the prison population. And to be fair, the design professionals in this case may have well done that, and it just, their advice wasn't followed. But it's a good example of courts really looking at climate change as being foreseeable. And so, you know, when designing, you really need to look at what potential weather or other impacts might have moving forward. So that kind of wraps up the tort duty. And so just before we get into fiduciary, which is kind of the most obscure of the 3, Tort duty really is a duty that's imposed by law outside of any contract, that you will not harm those people that is foreseeable that negligent acts could harm. And so you want to just keep a lookout as to, who are the universe of people that your work could potentially impact moving forward. And it tends to be a pretty, it's a lot of people that are just on the project and out of privity of contract with you that you end up dealing with, but it can end up being, other subclasses of people that are out there that are potential litigants, and including the occupants of some of the buildings that are being designed. So let's segue now to the third type of duty, which is a fiduciary duty. And so fiduciary duty is a duty that you probably have dealt with the least, if at all, in your practice. But it's something that is getting a lot of traction legally right now, and is something that I think all architects and engineers should be aware of moving forward. What is a fiduciary duty? Essentially, as it says here, it's an affirmative duty from the professional to the client, and it requires the fulfillment of duties of care and loyalty to the client or the principal. To boil it down, it's a duty to place your client's needs ahead of your own. It's the highest duty you can owe. You see it with investment professionals, doctors, lawyers, accountants. It's essentially comes from a place of law where you have asymmetries of information. So if one party has greater knowledge or greater expertise, then it puts the other contracting party at a disadvantage. Then you can a lot of times have a fiduciary duty. Fiduciary duty also comes out of a place of equity. And so it's really there to kind of plug those situations where there's some sort of wrong that occurs that tort law and contract law somehow doesn't fix. It's kind of, it's meant to avoid loopholes in a lot of ways. But you see it come up fairly frequently in architect and engineering law. And, the reason it does is because you end up with some fact patterns where, tort and contract doesn't really work in a lot of ways. And so it's an evolving duty. And one kind of cool thing about common law, which is where fiduciary duty kind of comes out of, is that it really does evolve. And so the example I always give for the kind of the evolution of fiduciary duty or any kind of duty is that, doctors used to be able to kind of go in and operate on people and not really kind of tell them what they were doing. And it wasn't really considered a problem. And in 1914, there was a case where a patient had consented to have an abdominal surgery, essentially. And the surgery was to remove an abdominal tumor. But the patient was never told she had a tumor. It was never really told that there could be any potential adverse outcomes from the surgery. Now, today we find that all to be kind of barbaric and crazy, but back in 1914, that was just really the standard of care for doctors, is that you could operate without really telling people kind of what you were doing or what the risks were. And so this patient ended up having a bunch of complications and ended up suing the doctor. And in the case, when it came before the court basically said that every human being has a right to determine what should be done with his or her body. And a surgeon that performs a surgery without the full informed consent of the patient commits a battery and is liable for damages. In other words, that physician breaches its fiduciary duty or his or her fiduciary duty to his or her patient. And so, there's a lot of people today that think that fiduciary duty for architects and engineers is moving in that direction. There's a lot of people that think it is not, but I think it's something that is just good to be aware of, because the duty can really expand as the law expands. So how does this kind of come up in day to day? So one of the things that you'll see in contracts sometimes is you can assume, and this kind of goes back to the contract theories that where you can kind of decide what your obligations are going to be, but you can assume a duty, fiduciary duty under contract. This one says architect, but we can substitute engineer. So you can say, you know, the engineer understands and acknowledges that the primary relationship between the owner and the engineer is fiduciary in nature and characterized by the trust, reliance, and confidence the owner places in the engineer. So if you put that in your contract, you've officially assumed a fiduciary duty. I don't see that very often in architects or engineers contracts, but I have seen it, and it is something that you can agree to by contract. Like I said earlier, once you agree to that duty, it is essentially a duty to place your client's interests above your own. And we're going to talk a little bit about what that means. Who do you owe a fiduciary duty to? As we just talked about, you can assume a fiduciary duty in contract, but you can also have a fiduciary duty imposed on you as a matter of law, kind of like a tort law, like a tort duty. And a fiduciary duty exists in relationships that are not at arm's length. So if you recall, when we talked about contracts, we assumed that the parties had equal bargaining power and can negotiate a contract. Fiduciary duty assumes that those relationships do not exist and that there's asymmetries of power, and that the principal lacks meaningful capacity for oversight to prevent opportunistic behavior. So you can see this, you know, in like a trustee situation. So if you're the trustee for somebody that is a minor or not competent to manage their own affairs, and you have the ability to handle all of their finances and their, you know, personal matters, you can easily see where you could use that asymmetry of power for your own personal benefit as opposed to benefiting the person for whom the trust is there for the benefit of. This can also arise in an architectural or engineering setting. And we're going to talk about that in a little bit, but let's start with consensus docs, because there's a lot of effort that's been put in to form contracts or contracting generally, where both architects and engineers spend a lot of time trying to disavow any fiduciary duty. And the reason for that is that they want a contractual arm's length relationship, and they don't want this higher fiduciary duty that can exist. And so this is just an example, but you can see it in a bunch of different contracts. But if you look at consensus docs, the 240 standard form between the owner and the architect engineer, you'll see the architect engineer accepts the relationship of trust and confidence established by this agreement, and covenants with the owner to cooperate and exercise the architect engineer's skill and judgment in furthering the interests of the owner. The architect and engineer represents that it possesses the requisite skill, expertise, and licensing to perform the required services. And so when we look at this agreement, if you take out the words trust and confidence, I don't think you have anything other than just a standard duty. Some courts and a lot of lawyers will tell you that once you put in that relationship, you know, accepts the relationship of trust and confidence, that's starting to signal a fiduciary duty. And I know, you know, some people have avoided or, you know, this provision in consensus docs for that reason. So those are the types of words that can start to potentially give rise to a fiduciary duty, even if you don't want to accept a fiduciary duty. So you want to make sure when you're looking at your contracts that you are not accepting that higher standard of care if you don't want to. If you do want to, you can go back to the slide we looked at earlier where you just outright say that you're accepting a fiduciary duty to your client. If you do have a fiduciary duty, what does that mean? And I know we've said it's, you know, the highest standard of care and you have to put your client's interests above your own, but what does that really mean? And there's a bunch of stuff that it means, and there's a bunch of stuff that we don't really know yet legally what it means as this area of law continues to develop. But generally what it means is that you have a duty to protect the owner's interest, and a design professional needs to avoid conflicts of interest and not advocate solutions contrary to the owner's stated positions, even if an engineer believes it's required by the canon of ethics. And we're going to talk about this in a minute or two, but for the most part, the canon of ethics that most engineers follow does say that engineers will disclose all potential conflicts of interest that could influence or appear to influence their decisions. So I don't think there's anything really controversial in that. The canon of ethics also indicates that engineers shall not accept compensation for more than one party for services in the same project, unless the circumstances are fully disclosed and agreed to by all parties. And so there you kind of get into avoiding the conflicts of interest. It does say the canon of ethics does indicate that engineers shall not solicit or accept financial or other valuable consideration from outside agents in connection with the work for which they are responsible. So all of that is consistent with the canon of ethics. Where you might get into some maybe potential conflicts, maybe not, is when we get into green building, and we're going to talk about that in a slide or two. But what else is required by a fiduciary duty? You have to meet the owner's project requirements, their schedule and budget, and therefore you have to really understand how design decisions impact the owner's risk profile and long-term goals. You have a duty to disclose how you're providing design services, including a duty to disclose when design services are outside the design professional's expertise. And so that kind of takes me back to the prison case we talked about with the Fourth Amendment rights. If I'm an architect and I undertake an assignment to build a municipal lockup facility, and it's the first lockup facility I've ever done, do I really understand what a prisoner's Fourth Amendment rights are? Is that within my area of expertise? Arguably not. And is there a subconsultant I can hire? But when you have a fiduciary duty, you really have a responsibility to say to the client, like, hey, I've never done this before. And so you need to understand that going in, and you can explain, I'm going to hire a subconsultant, or I think I can figure it out. And as long as the owner agrees or the client agrees, you can move forward. But you really need to disclose areas in which you do not have true expertise. A fiduciary duty also requires the design professional to protect the owner's decision-making capability to make decisions that materially impact the project. And a lot of those decisions have to do with cost at the end of the day. And so, I had a situation once where there was a hotel being built, and the design, and I can't remember what the finishes were, but there was some finish on the door handles to the hotel rooms. And, it was a brushed copper, and they wanted to move it to bronze or something. I don't know. But the design professional in that case kind of made a decision that the aesthetic required that the handle have a different finish, and they made it to be consistent with the overall aesthetic of the building. But at the end of the day, it ended up being something about, like $100 more per door handle. And when you multiplied that across, 1,500 door handles, it ended up being $150,000 surcharge to the owner that the owner never had any knowledge of. And so if you have a fiduciary duty, that's not really acceptable, because you need to tell the owner that, you're going to have this, cost increase if you make this design change, finish change on a door handle, so that the owner is able to make those decisions on their own. And, a lot of people may be saying, well, I do this anyway. and that may be all, that's great. It's just that this is what a fiduciary duty essentially requires. And so where do I see this kind of coming in a more day-to-day manner? So the NSP Code of Ethics requires, it says essentially that engineers are encouraged to adhere to the principles of sustainable development in order to protect the environment for future generations. If you look at the AIA, they're even stronger. They have, the AIA says basically that in performing design work, members should be environmentally responsible and advocate sustainable building in site design. And so what does that, what does that really mean if you owe a fiduciary duty to your client? So if you have a fiduciary duty, can you advocate for green building? Can you encourage your client to build green if that's, something that you want to do? And so, an example here that I've kind of seen in real life is that there was an architectural firm hired by an owner for the large expansion of a hospital. And the architect was hired, basically based somewhat on its reputation for being, an expert in green building design. And so the hospital wanted to increase occupant health due to, proper selection of materials and for it to be, green, and that they would have an overall better patient experience. And so one of the materials selected by the architect was a low VOC floor covering adhesive, which was supposed to be environmentally friendly. And, shortly after completion of the project, the flooring adhesive failed and a lot of the flooring had to be replaced. And so the architect there, kind of claimed that the selection of the low VOC adhesive was done for the greater good of society and for the occupants of the building, and that the cost to replace the flooring was therefore an acceptable outcome. And so, the questions there are, if you owe a fiduciary duty, did you tell the owner what the failure rate of that product would be? Did you tell the owner what a non-green, maybe flooring material would cost, or what the outcomes of those would be? And so you really need to pay attention to what you're telling the owner and what sort of autonomy you're giving the owner over their choices moving forward. How does this all come back in real life? And so this is actually a case that went to litigation, and it's kind of the big, scary fiduciary duty case that's out there. It's been out there for a couple of years, but I think it kind of embolizes all of the issues that we've just kind of been talking about with fiduciary duty. And so I want to take a minute and kind of talk about it. So the city of Victorsville had a project, and they basically hired an engineering firm called Carter and Burgess to determine the feasibility of building a power plant to attract new businesses to the city of Victorsville. So the idea was that they would build this power plant and they'd have these new businesses come in. And so by way of background, the city of Victorsville had about 160,000 residents total. Carter and Burgess, who was later acquired by Jacobs Engineering, had approximately 50,000 employees. And so, as I had talked about earlier, with fiduciary duty, is you do tend to get these asymmetries in power. And so in this case, we don't have a contract that has a fiduciary duty. This is probably, I've never seen the contract, but I imagine that the city of Victorsville and Carter and Burgess had kind of a standard form contract. And so Carter and Burgess goes in and does this feasibility study for the city of Victorsville. And they essentially say that, full steam ahead, should build the power plant. And one of the arguments the city of Victorsville made when this all went wrong is that they really relied on Carter and Burgess because they, they're just a small city. They're just, the city board, and they don't really know anything about building a power plant. And they're just completely relying on Carter and Burgess / Jacob Engineering to give them advice. And so the city then contracts with Carter and Burgess to design the power plant. And so Carter and Burgess does that. While they're in the design phase of the project, they actually take several all expense paid trips to some of the potential new businesses headquarters out of state. They go and tour their facilities and see what they're going to need in terms of, I guess, power usage and things. It's unclear to me whether those trips were ever disclosed to the city of Victorsville, but there you have, again, you have an engineering firm that's arguably getting some sort of benefit for itself personally by taking these all expense paid trips. Maybe not, but you could see the argument. And so the project goes on, and eventually the project ends up being canceled due to numerous cost overruns and delays. And so, during the feasibility phase, Carter and Burgess had done a bunch of economic pro formas for the city of Victorsville. And so those pro formas, said that the project would all be done and it would all be profitable and, on and on and on. So project's canceled, and then Carter and Burgess sues the city of Victorsville for $106,000 in unpaid fees. And Carter and Burgess comes back and sues. The city comes back and sues Carter and Burgess in a countersuit for the full amount of the project, saying that Carter and Burgess was negligent in both the feasibility study and the design of the building. And they sue for $52 million. And in this case, which ended up getting tried, what the city of Victorsville argued was that Carter and Burgess owed it a fiduciary duty. And they said, look, we have this asymmetry of information. We're a small city. We were relying upon them to do the feasibility analysis. We were relying on them to design the project. And we were relying on them to, kind of bring these businesses in and for it all to be economically viable at the end of the day. And a jury awarded the city of Victorsville $52 million on that case, finding that the Carter and Burgess breached its fiduciary duty to the city of Victorsville by essentially, placing its interests ahead of the its clients. And the court seemed to have a problem with the fact that it both did the feasibility study and the subsequent design. It had the court pointed out multiple times that the contracts listed this Carter and Burgess as a city engineer while doing the feasibility studies, meaning that it was representing the city's interests during that time. And then, entered into a design contract for its own financial benefit. The court seemed to have some issues, although I don't have all the details, with the trips that that Carter and Burgess took with the other clients, presumably soliciting business for other projects when those entities moved to the city of Victorsville. And ultimately, a lot of that judgment was paid after, I think the case was settled after the judgment came out. But, the other issue you have, and it's something that we should mention here, is that the insurability of these breaches of fiduciary duty is always in question. And so there was a lot of issue after the verdict came out as to how the verdict was going to get paid. But I believe it eventually did. But it is really a case that has kind of sent a lot of kind of legal minds and, architect engineering firms, to really reflect on, do you owe a fiduciary duty, and what does that mean? So those are essentially the three kinds of duties that we have. This last slide kind of is a summary of what those duties are and how they all kind of play out. And so if we start in the middle, we have the contract duty, which is, again, your arm's length relationship. You have two kind of equal parties that are contracting to generally build a building or build a highway or do something. And they can each agree to the terms and conditions. They can agree to who they owe a duty. They can agree to what the scope of work is going to be, and they can agree to the allocation of risk. If something goes wrong, they can agree to mediate or arbitrate, or how disputes are going to get resolved. And so generally speaking, it's a good way to run your business. You just have to make sure the contract says what you want it to say. Then off on the left, we have the tort relationship, and this is kind of a distant relationship. And, you are the engineering entity, and you have this kind of tort duty that goes out to a bunch of people that are foreseeable to you, that just are milling around in the world. They're the landowner if you don't moor your boat. They're the, but not the woman at the end of the railroad tracks. And so they're definitely, in all likelihood, other contractors on a project. They're potentially the project owner if you're not in a direct relationship with them. They are visitors to a project site for sure if they're injured. They are pedestrians or passerbys if they're, injured, or property around the project if it's harmed in any way. But there's a whole world out there of people that you could potentially owe a duty to. And then we come to the fiduciary duty, which is the last duty that we talked about. And this is a really close relationship, one of kind of principal and agent almost, and so you have a client and a licensed learned professional. And so they have this asymmetry of power. And so you're going to have a different type of relationships. So unlike the contract where you're equal and you each can kind of come to your own terms, the fiduciary relationship, one party has less power in the bargaining relationship and less knowledge about the subject matter of the contract. And this can arise, as we saw in the city of Victorsville case, depending on who your client is. And so if you're, if you're contracting with Exxon Mobil, you're probably not going to have a fiduciary duty. But if you're contracting potentially with the city of Victorsville for a really large project, then maybe you do. And maybe you do, even if you are contracting with Exxon Mobil, if you have language in your contract that potentially gives rise to some sort of fiduciary duty. And so it's just something you want to look at and keep in mind as you're practicing, and how the world of people to whom you owe a legal responsibility is out there. As I promised at the beginning of the presentation, most of the stuff we talked about today is in Illinois. Every state has its own set of laws and rules that regulate the practice of engineering. And so laws can vary state by state. If you have any specific questions or have any, follow-up inquiries, I'd be more than happy to answer them. My email address is kjones@o'haganmeyer.com. And I'd be, like I said, shoot me an email, and, I flip you one back, or I'd set up a time to talk. And really appreciate you sitting through today on this topic, and hope to hear from you in the future. Thank you.